my faith arising. I'm crawling out the trenches, holding me, my life.
Hello visionaries, welcome back to my channel. My name is Maresa Talbert, founder and CEO of Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law. We got a good one today, y'all. Y'all already saw the title, so you know that today we're talking about trademark infringement. What is it? How is it determined? What to do if you get accused of trademark infringement? But better yet, what to do if somebody infringes on your trademark? Let's jump right into it. So what is trademark infringement? Trademark infringement is the unauthorized use of a trademark or a service mark. If you don't know, a service mark is a trademark that is used for services. Let's check out this short clip that breaks it all the way down.
I got a problem because I don't understand why you got to take something that's perfectly good and mess it up. See, brand names mean something. You understand?
Shut the up! Go ahead, Frank. I'm sorry about that bull.
Blue Magic, that's a brand name. Like Pepsi, that's a brand name. I stand behind it. I guarantee it. They know that even if they don't know me any more than they know the chairman of General Mills.
Talking about,
what I'm talking about is when you chop my down to 1, 2, 3, 4, 5%, and then you call it Blue Magic, that is trademark infringement. You understand what I'm saying?
All due respect, Frank. If I buy something, I own it.
No, that ain't true. That ain't true.
Buy a car and I want to paint it. I can paint it.
Yeah. This is what I'm saying to you, Nick. You don't have to. It's good enough the way it is. You can make enough money off it the way it is just by calling it Blue Magic. Anything more than that is greed, son.
What do you want, Frank? You want me to change the name on it?
I would have to insist that you change the name.
Fine by me, Frank. I'll call it Red Magic.
Even
though they don't sound as good.
I don't what you call it. Put a chokehold on the mother and call it Blue Dog. You know what I mean? I don't care. Just don't let me catch you doing this again.
Catch me? Infringement? Insist? I don't like these words as much as please. Thank you. I'm sorry to bother you, Nikki. These are better words you use. You come to my club without an invitation. Hear me?
In this clip, you have Denzel Washington starring as Frank Lucas. If you don't already know who Frank Lucas is, look him up. But basically, he's at the top of his game for dealing a certain kind of product. I'm not going to say what it is, but you can use your context clues. So, he's at the top of his game, and he goes and confronts his competitor, who is played by Cuba Gooding Jr. So, Gooding's character is cutting the product. You know what that product is. I ain't gonna say it. But it's making that product a little less effective. Now, even though Gooding is cutting the product and changing the potency, he's still calling it Blue Magic, which is Frank Lucas's brand. And you hear Denzel's character telling him, once you cut it, it's no longer my product. You can't call it Blue Magic. You're diluting the brand. This is the perfect example of trademark infringement. Remember when I told you that trademark protection is not so much about protecting you as the trademark owner, as much as it is about protecting the consumer from buying something that they thought was yours, but it's really not. So trademark protection is about making sure that I don't go buy an Nike shoe thinking that it's a Nike shoe. It's not fair to Nike. Not only does Nike miss out on the money I would have spent with them by me buying a knockoff, but they also lose out on the goodwill, because if I think this is a Nike brand and it's of lesser quality, then I may be inclined not to buy any Nike products any longer. You get me? So that leads me to my next point. How is trademark infringement determined? So first, we need to make sure that there's a registered trademark. You can't just be claiming trademark infringement without a registered mark. It don't work like that. Sorry. But there are 8 elements that are considered when determining whether trademark infringement has occurred. The first question we have to ask is there a likelihood of confusion? I won't hash out a likelihood of confusion here in this video, but in my last video, which I'll link up above and in the description box below, you can learn all about what a likelihood of confusion really is. But going back to my last example, if I confuse a knockoff brand with Nike, then there's a likelihood of confusion. In fact, there's actual confusion. And so that would lean in favor of trademark infringement. Next, we look at how similar are the goods and services for both companies or for both trademarks. Basically, we're looking at whether these two trademark companies are competitors. So is this a Pepsi versus Coke situation? Is this like a Reebok versus Adidas situation, where those are direct competitors? Or is it something like Nike versus Ralph Lauren, where there's some similarities in the goods and products that they sell, but they don't exactly market to the same exact audience? Or is it something more like KitchenAid versus Google, where they are completely unrelated? We will also look at the strength of the non-infringer's mark. So a couple videos back, I talked to you about the hierarchy of the strength of trademarks. Again, I'll link it up above and in the description box below. If you haven't already watched it, you should check out that video because it'll really help to explain the strength of trademarks in greater detail. Bottom line is, it's not a big deal until it is. And it is considered when determining trademark infringement. Another factor that we look at is how both trademarks or companies market their goods and services. Do both companies have a strong online presence? Do they both have an e-commerce website? Do they both have a brick and mortar location? And it's not just comparing how they market their trademarks, but also how similar are their target audiences. Another factor we consider is the degree of care that is used when someone is purchasing either the good or the service. I typically refer to this as the sophisticated purchaser. So we look at whether this trademark is good for an impulse buyer, such as a Frito-Lay bag of chips or a Chick-fil-A sandwich, or on the other hand, whether consumers take much more thought and consideration into choosing or purchasing this type of good or service. So they're much more likely to compare brands against each other. Examples include buying a laptop or a car, or even choosing an attorney. So both trademarks would be compared against that metric. The sixth factor is looking at the infringer's intent on choosing the trademark that they chose. We don't really care, but it's taken into consideration. The seventh consideration is there any evidence of actual confusion? So remember, earlier I talked about me confusing Ike with Nike, and I said there's a likelihood of confusion, but there was actual confusion because I went as so far as to purchase the knockoff. So both the likelihood of confusion and actual confusion are both taken into account when looking at whether trademark infringement has occurred. And last but not least, we're going to look at the likelihood of expansion into a particular market between the two trademarks. So let's take Louis Vuitton, for example. Louis Vuitton started off selling leather goods, primarily luggage. And let's just say, around the same time that Louis Vuitton was getting started, there was another company, LVV. And they started selling shoes and coats. If Louis Vuitton claimed trademark infringement, the court would look at whether it's foreseeable that Louis Vuitton would expand into selling clothes and shoes and outerwear and even other accessories. So if there's a likelihood that the senior mark would or could expand into this particular market, you might have trademark infringement. Now, let's shift that example and say Louis Vuitton starts out selling luggage and handbags, and LVV starts out selling bedding. And then years later, the two markets converge, where both are selling handbags, shoes, accessories, outerwear, bedding, home goods, that sort of thing. It might be a little less foreseeable to see one or the other crossing over into each other's markets. So that is also taken into consideration when determining whether there's trademark infringement. So what can you do if you are accused of trademark infringement? If you have ever been accused of trademark infringement, you're usually notified by what's called a cease and desist letter. This basically informs you that the trademark owner believes you've infringed on their trademark and they're demanding that you stop. If you've ever received a cease and desist letter in the past, it can be pretty rattling. So you'd want to consult an attorney to respond appropriately to the letter. You do not want to ignore the letter because a cease and desist letter is usually the first step before someone moves ahead to a lawsuit. If you believe that you have the rights to use the mark that you're using, you still want to respond to the letter and defend your use of the mark. On the flip side, if you are a trademark owner and you believe someone has infringed on your trademark, then you would send a cease and desist letter. Again, I would recommend consulting with a trademark attorney to help write this letter for you. And of course, Talbert Law can assist with that. But if your letter goes unanswered, then you can file a civil action in federal court, where the penalties include a court order to stop infringement, a court order to destroy any infringing materials, and a requirement to pay damages and lost profits up to $150,000 per occurrence of infringement. And let's not forget the recovery of attorney's fees and court costs. So it can get real quick. Well, I feel like I've given you a wealth of information, so we'll end it here. Please share in the comments any stories you have of trademark infringement. Until next time, this is Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law. I'll see y'all in the next video.